This week, many were alarmed after it was reported that sharing Netflix passwords could be a federal crime. That assertion was based off of a ruling from the U.S. Ninth Circuit Court of Appeals. The ruling is United v. Nozzle, and they found that password sharing was a crime under the Computer Fraud and Abuse Act, the CFFAA, and that's a 30-year-old law that famously prosecuted hacker Aaron Swartz and has been called the worst law in technology. The ruling didn't have anything to do with Netflix. It had to do with an employee who quit his job to start his own business. When he left, the employee held onto his login credentials so he could use his former employee's database. That defendant, David Nozzle, was sentenced to prison, probation, and was fined $900,000 in restitution. Right now, I'd like to welcome attorney Mark Lee to weigh in on this case. He's a partner with the firm Schneider, Harrison, Siegel, and Lewis. Welcome to the program.
Thanks for having me.
Mark, is this another way the government will crack down on cybercrime and serve as a deterrent, or is this a case being blown out of proportion here?
Well, it's definitely going to serve as a deterrent, and it definitely is a tool that the government has to crack down on cybercrime. I think that there probably are some applications of the statute that could be blown out of proportion, but if you look at the court's opinion, which I'm sure you have, and your viewers have, maybe some of your viewers have, the reasoning is pretty narrow, but there are some causes to be concerned about future application of the law.
A lot of people would look at this and say this case is all about theft of trade secrets and accessing your old employer's database and computer system without permission, and it has nothing to do with sharing Netflix passwords.
Well, I'd be one of those people. I mean, I think the Court of Appeals focused on the actual revocation of access that Nozzle had because he was in a dispute with an employer. He was preparing to leave and go start another company and was stealing information from a database. He had specifically been forbidden from doing so. Used another employee's login credentials to get access to that database. So a lot of the reasoning behind the decision had to do with stealing trade secrets. And the federal government prosecutes those crimes for a lot of reasons. Now, in theory, it could become a crime to give someone else access to a database when it's not a trade secret, an offense involving trade secrets. But in my opinion, it's highly unlikely that would happen. I think there could be legislative fixes coming down the pike as well. But with respect to what's said and reasoned in this opinion, it seems pretty narrow in my view.
Now, following the ruling, has Netflix or any other streaming services done anything to suggest a crackdown on password sharing?
I'm not aware that they have, and that's obviously more of a business decision than a legal one. I could probably predict that they would, though.
Do you think eventually, when they have enough of a customer base, streaming services will crack down on those freeloaders?
They probably will. Again, that's more of a business decision than a legal judgment, because you can imagine a scenario where freeloaders, as you said, are costing services like Netflix money. And if I have one password and 20 people are using it, probably is something that Netflix and other companies like Netflix would want to crack down on.
Now, considering it's a 30-year-old statute here, does this CFAA statute that the ruling was based on need to be revised to better suit the modern computer age?
Well, that's true for a lot of statutes, and that's definitely true for a lot of statutes involving technology. So I think that there are appropriate issues for the Congress to look at. There are a lot of concerns raised by the dissenting opinion in the Nozzle opinion that I think the court or Congress will look at. A lot of times that's what dissents do. They provoke Congress to act, and in a case like this, it can affect a lot of commerce. There's good reason to believe that it'll happen.
Now, this case reminds me of a few years ago when the record industry targeted kids who pirated music. Is this case anything like Napster or any of those cases similar to that?
Well, again, I think it would depend on how you view the case. If you're you're viewing it through the hypothetical lens of all of the potential prosecutions that would come out of it, probably. But what was at issue in the Nozel case was a theft of trade secrets, a theft of proprietary information, and those are typically the types of cases that the government prosecutes. They don't usually prosecutes criminally, rather. They don't usually go after people who are just trading information or trading music online. Now, there may be civil penalties for that type of action, but in terms of a criminal prosecution, it's not something that is normally seen. But again, that's why, with your question, Congress might need to get involved and make certain that it's not a crime to do so.
The record industry made quite a few enemies there and also failed to solve the problem. I'm not sure that live streaming will make that same mistake. If it's any consolation, Netflix executives have noted in the past that password sharing helped create future subscribers and called it a positive thing. So I don't think all the Netflix password sharers have anything to worry about. Attorney Mark Lee, thanks for weighing in.
All right, thank you.